Founded in 2010 by Elliot Tabele, FJerry has built a strong cult following through viral meme content. Having an impressive resume of over 30 million followers across all accounts, they've been recognized as one of the internet's top grossing influencers, with reports stating they command up to $30,000 per sponsored post. Forbes claimed that Tabele was on his way to becoming the Rupert Murdoch of social media. To this day, FJerry maintains a strong business across various social media properties, including Dude with Sign, which was launched in 2019. The account features employee Seth Phillips holding cardboard signs with statements protesting everyday annoyances. With close to 8 million Instagram followers, the account regularly solicits hundreds of thousands, if not millions, of likes, comments, and impressions. The account has been featured in Forbes, Men's Journal, and Us Weekly. In addition to the official post, Dude with Sign has spawned a universe of people using Dude with Sign as a meme template. Users from all corners of the internet have taken Dude with Sign and posted their version of what he would say, which, as we've learned, FJerry is not a fan of, having filed over a dozen lawsuits against those who have used the Dude with Sign meme template. Rob Freund is a lawyer who specializes in marketing and e-commerce issues for brands, agencies, and creators. He's the leading expert on the topic and was willing to sit down for an interview with me to discuss the FJerry lawsuits. Enjoy. So, Rob, how can you sue over a meme?
Well, there's a number of issues to think about. In these cases, what FJerry is saying, FJerry is the entity that owns the rights to these images that are being used, and to the Dude with Sign himself, the right to enforce the dude's publicity rights. So those are the two angles here. The cases are about the use of the images themselves, whether that's copyright infringement or not, and then the use of the dude himself, like the image of the Dude with the Sign, commercially, which FJerry says violates the dude's publicity rights. So if you're taking content you didn't create, one or both of those issues could be at play, especially if you're using that content commercially.
But aren't memes supposed to be altered and shared? Isn't that the whole point?
That is the whole point, and that's why these cases have caught some people by surprise, especially the brands. The whole point of memes is to share them and put your spin on them and spread them around for humor or for whatever other reasons. But the issues happen when you're using memes for a brand's advertising. At that point, you're using them for a commercial purpose, and your ability to use them is much more restricted.
So what do you mean by that? What do you mean by commercial purpose, and what are these restrictions?
Sure. So for some background, anytime that you take a piece of content that you did not create and you copy it, whether that's by reposting it or just taking it and running it as an ad or anything like that, you are violating the copyright of whoever created that original content, unless you have some kind of agreement with them that lets you copy it or repost it or whatever you're doing with that content. So that's sort of the starting point.
Gotcha. Is every meme copyrighted?
So some are, there's a difference between whether something is protected by copyright and whether a piece of content is registered with the Copyright Office. So anytime that anyone creates a new creative work, an original work, and they fix it in a tangible medium is what the law says, meaning, you take a photo or you paint a painting or make a drawing or something like that, at the time you create it, you own the copyright in that work. If you register that work with the Copyright Office, that is required for you to sue if someone infringes your copyright. So by default, everything that's an original work that's fixed in some kind of medium is copyrighted. Whether you can do something about it and go to court over it depends on whether you've registered it with the Copyright Office.
Are the Dude with Sign memes registered with the Copyright Office?
The images that are being used to create the meme template or that these brands are taking and modifying, those have been registered with the Copyright Office.
So if I have a meme, the base registered photo, and I alter it to say whatever it is I want to say, isn't that fair use?
Here's the lawyer answer. It depends. It can be. And fair use is one of the most complicated areas in copyright law for sure. I mean, we could spend probably an entire law school semester talking about what is and is not fair use. And the thing about fair use is that it's a defense to infringement. So in other words, it's if you have some kind of activity, whether it's copying or modifying or creating some work based on an original that would otherwise be infringing, there are situations where you can ask the court to say, okay, you copied it, it would be infringement, but what you did is fair use. And there's a number of factors that the court has to assess in determining whether something is fair use. And those factors include like the nature of the secondary use of it, whether it's commercial, whether it's transformative, the effect on the market for the original. And the thing is that because it's a defense to infringement, it has to be determined on a case-by-case basis. You can't really just say it's fair use, period, and then expect that to be sufficient. A court has to figure it out, analyzing the facts of each case on a case-by-case basis. So can some modifications to a photo in some context be fair use? Absolutely. But it's not a black and white kind of analysis.
And how does the commercial purpose of the underlying post affect the fair use or copyright analysis?
In these cases in particular, what FJerry and the Do with Sign are saying is, look, we created these photos and we do in fact license them to some brands who want to do this the right way and use these image formats in their advertising. And so these other brands that are just taking them and running them as ads are basically free riding on it, and we're losing out on that revenue stream when you go and do this. So they're saying that the brand's use is commercial, and it does affect the market for those works that they are in the business of licensing to brands who want to do the same thing.
Gotcha. Now, is what FJerry's saying by this that they're the only ones that are allowed to hold a cardboard sign and put some sort of meme on it?
Absolutely not. And if these brands had just had, say, one of their employees or some creator that they work with hold up a cardboard sign with something written on it, that would not be an issue. You can't have a monopoly on something as basic as that. The problem is that they took the exact photos, all they changed was the word on the cardboard sign, and that's how they ended up in this trouble in the first place.
Okay, so transitioning to the right of publicity, the second issue that you stated earlier, what is the right of publicity?
The right of publicity is the right of an individual to control the commercial use of their name, image, and likeness. And it doesn't apply just to celebrities or famous people. In states like California, everyone has a right to control the commercial use of their likeness, and you don't have to be an influencer or anybody with any kind of following to bring that kind of claim. And so here what they're saying is, like, the dude with sign himself, I'm forgetting his name right now, but he has the right to control the commercial use of his image. And these brands have not obtained a license or any kind of or have any agreement with him that grants them the right to do that. His face is in these ads. It arguably implies that he's endorsing these brands in some way. And so you have a pretty straightforward publicity rights claim there.
So is the right of publicity state by state, or is this a federal claim?
It is state by state. So sometimes you'll see cases that are in federal court that allege a federal claim like copyright infringement, or sometimes a Lanham Act false endorsement claim, and they'll tack on a state law claim for publicity rights violations as well. And that's what FJerry is doing here.
Right, because from the complaint, it appears New York has a right of publicity claim, and that's they're suing in federal court in New York, and
Correct.
That's why they're attaching it. Correct.
Yes.
Okay, so I guess the third prong, because there in all of these complaints, there are three causes of action, is false endorsement. You briefly touched on it earlier. What is that?
False endorsement is a claim that's available under a federal statute called the Lanham Act. And what you're essentially saying is that you are taking my image or likeness or in some way conveying to consumers that I endorse this product and I explicitly endorse it. And a reasonable consumer looking at this advertisement would believe that I have some connection or affiliation or am endorsing this product when that's not the case.
So let me give you a hypothetical. Let's just say my subreddit posts a photo of me in front of an Arby's, and it says, "My name's Attorney Tom, and I love Arby's," even though I hate Arby's. Is that a false endorsement?
Well, it would, in that situation, you weren't involved with that ad at all. You weren't involved in creating it. You have no control over who posts what on the internet. And so if anybody were responsible for some kind of false advertising situation, it would be whoever created it. But those situations come up more frequently when the brand itself is using a celebrity's likeness or something like that and running ads with it. Like if I had a perfume company and I want to run ads with Taylor Swift, like Photoshop holding my perfume, that is probably going to be or could give rise to a viable false endorsement claim, because obviously you're trading on Taylor Swift's persona in promoting the brand. But if some random person on the internet created that image and posted it, it's not really a claim there because the brand had no involvement with it.
Gotcha. Okay, so we pulled about a dozen complaints from FJerry, and they all are nearly identical. And I only say nearly as a catch-all in case I might have missed a word or two, but they are all very close, nearly identical. Is there any significance in that?
Legally, no. It's not uncommon for plaintiffs' firms that pursue these sorts of claims to have verbatim or nearly verbatim complaints essentially ready to go for copyright infringement. Some of these firms are set up to do it at scale, and they'll pump out, dozens of copyright infringement claims or lawsuits a day. And so what it does indicate is that FJerry is prepared to send a lot of demand letters and potentially file a lot of cases, which they have done. And that the facts are pretty much the same in each of these cases. Brand takes dude with sign, changes some words, and you have yourself a copyright infringement and or publicity rights lawsuit ready to ship.
Does FJerry have any sort of obligation to send a demand letter first, or can they just file a lawsuit?
They don't have any obligation to send a demand first. And that's a common misunderstanding that I hear from some brands and other people online, is that, well, if somebody has a problem with this, I'll just take it down. There's no requirement that you send a demand letter. I know that FJerry does send demand letters before suing, so it's impossible to tell how many demand letters have been sent because they're not public. But I have seen what the demand letters look like and what they come out asking for. And
how do you think FJerry is patrolling the internet looking for potential infringements?
There are service providers that will do that for you. I don't know exactly the mechanics of how it works, but there are ways to search the internet for instances of a photograph or other piece of content and identify where on the internet it is. So likely they have one of those services that's helping them do that. But also I see these ads just passively. I'll be on Instagram and I'll see another brand using the dude with sign meme, even though I talk about it all the time. I've tweeted about it many times and I still see it. So it's probably a combination of having somebody troll the internet for them, but they probably are made aware of it through people on their team just looking around, looking on Instagram, looking on Twitter, and some combination of that.
Now, from looking at the PACER, it appears that once these cases get filed, almost all of them are dismissed after just a few months. What does this mean?
That means that the defendants are settling. That's almost certainly what that means. So a lot of brands it's common for a defendant to sort of ignore a demand letter. Maybe they think it's not serious. And then when they're actually served with a lawsuit and realize they're in federal court, that will usually quickly bring someone to the table. And it's not the sort of case that's really worth fighting. Or most brands would probably say that the cost benefit here of trying to argue that we have fair use or something like that is not going to be worth it. And FJerry and many plaintiffs who bring these sorts of cases understand that they have that leverage and are often interested in settling it.
And how much money are we talking about here?
Well, FJerry opens their demands with the maximum statutory damages available for copyright infringement, which is $150,000, and they ask for their attorney's fees. So they come out swinging for the fences, maybe hoping that whoever's on the receiving end doesn't understand that that represents their FJerry's best possible day in court that's conceivable. They probably settle for some smaller fraction of that. Certainly not $150,000.
So hypothetical, if I purposely made myself a meme with the intent of having commercial users misappropriate my image and likeness, could I make a full business out of suing people who repost my meme?
Could you? Probably yes. Should you? Definitely not. There are entities who have done that before, but what you would need to show if you don't sort of extort settlements out of people who receive letters from you is that you actually had a good faith intention to use that, or that you did use that content commercially, so that you can say, by this brand taking my meme and using it, I'm losing out on that money. It hurts the market for the original content, and you would have a stronger response to a sort of fair use defense. But if you're manufacturing content, and especially if there's any record of you coming up with this scheme simply to extort people, you would find yourself with the ire of the judge for sure.
Well, shit. Okay. Am I going to get sued for showing you this meme?
Maybe. It's possible. If you mean just showing it on this video for purposes of our discussion, unlikely. If you were to run this as an ad on Instagram or Twitter or some other platform, somewhat more likely. It's hard to say exactly how aggressive FJerry is being in terms of the demands they sent.
Would you only say maybe in this circumstance because I'm showing you this meme in the greater conversation of us discussing what is and isn't?
Yeah, it's much less likely that would happen. Significantly less likely there'd be any meritorious claim. You have a really good fair use argument. We are literally talking about this and commenting on the situation. But it sort of goes to the bigger point of when you get the question, can I be sued for this? The answer is yes to pretty much anything. Anyone can file a lawsuit for whatever they want. There's no one at the court checking whether something's legit or not. And then the burden is on you to hire an attorney and deal with it. This one would probably not be that complicated to deal with, but it would still cost you some money to have to address. So can I be sued? The answer is almost always yes. Would I win? Really depends on what situation we're talking about.
Okay. So now let's just say I post this meme on my Instagram, and this really has no commercial purpose other than I'm seemingly being rude to the dude with the sign because he's suing a lot of people.
Yeah, I don't think FJerry would have any viable claim for you doing that. You're not a brand. You're not using it to sell any products or services by using it in this way. But again, the burden would be on you to make a fair use argument. And your analysis is going to be, okay, let's say, I don't know for sure, but let's say FJerry would go away for $10,000 to $15,000 for this sort of thing. It's probably going to cost you that to convince a court to dismiss it. So do you want to take that risk? I think the risk is probably pretty low here because it's so obviously, at least to me, not a good case for them to bring. But again, could they attempt to say that this is infringement and you don't have a fair use argument? They might try that, and you might have to pay to make it go away.
So could I use this as the thumbnail for the video? You're my lawyer. We have an attorney-client privilege. I'm holding you accountable here.
All right, with my credentials on the line here, I would not be especially worried about using that thumbnail. But if you get a demand letter from FJerry, please don't come to me and expect me to get you out of it.
Okay. Last one. What about it's a picture of me holding a sign of the picture with the guy with the sign calling him a jerk?
This is probably safer. But again, you have the original image within that image. So this is probably more transformative. You've added significant original content to it. You're using it for purposes of commentary and education. And, there's a humorous aspect to it. I don't think that FJerry they certainly wouldn't have a good claim against you. I don't think it'd be worth their while to try to do anything about that.
Okay. All right. I think that's pretty much it.